someone else's property.
Call, text, email, then join me along with the experts from Hollis, Wright, and Couch Sunday after the news at 10.
Car crash cases, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by Hollis, Wright, and Couch, are here to serve you. Your tough legal questions answered by our experts. The attorneys with Josh Wright from the Hollis, Wright, and Couch Law Firm and host David Lamb.
Hello and welcome into the attorneys. Appreciate you spending your Sunday evening with us for the next half hour. This is your opportunity to get your questions answered by experts, attorneys who know their stuff. Going to lead us through the conversation throughout the program. You'll see ways where you can call, text, email, and get in touch with us. Leading our way as we discuss premises liability is Tyler Vail from the firm Hollis, Wright, Couch. Tyler, good to see you.
Thank you, David. Good to see you too.
Premises liability, and we got Mr. Foster here to help us along.
Absolutely. Greg's a great guy. You know, he's an attorney at our firm, and you know, he's one of those go-to guys at our firm. Whenever we have an issue come up, you know, hey, what's the topic? What's the issue? Greg's handled it before. So he's got it. He's got the answer. So he's a perfect person to have on and address this topic with us tonight.
Well, let's jump into it. And I guess, you know, from a starting point, just help us understand what is premises liability law?
Yeah, premises liability law, it's in its simplest form. It's the body of law that determines the responsibility of property owners for injuries that occur on their property.
Okay.
You know, it can be anything from at your home, homeowners' responsibilities, or business owners' responsibilities,
right,
and several things in between. Yeah.
And just to add to that, David, I mean, pretty much what you need to think about is it comes in three categories, and this is a non-legal setup, but basically it's commercial, it's your benefit, and it's trespasser. I mean, it's three different categories that you will fall in when you go onto property. So you're either going for a commercial reason where somebody else is receiving a benefit for you being there, or you're going for your benefit. So you're going to a party, you're going to church, something that benefits you. Right. And then the third category is trespasser. You're not supposed to be there, but you are there.
Right. Let's start off with some examples too, in terms of cases, examples of premises liability cases. What are the most common ones?
You know, Greg can expand on this in a second, but I mean, everything from just a slip and fall at a grocery store, maybe they stepped on something wet, I mean, all the way to, you know, drownings in a pool, you know, and sometimes even folks next to you, property owners that are adjacent to you, may actually have some liability for things that are coming onto your property from their property. So it is a vast area of law, it really is, and so, you know, like Greg hit on it a second ago, I mean, it gets real complex. Like I said, in the simplest form, it's just about, hey, you were hurt on somebody else's property. Right. But then you got to go in and recategorize, you know, why were you there? You know, the knowledge somebody may possess. Has this happened before? You know, what actually, you know, amounted to cause this problem? And like I said, Greg's handled a bunch of different types of cases. He might be able to.
Right, and David and Tyler, I mean, what, you know, it comes down to your classification. Like Tyler's saying, why are you there? Okay, and so, you know, those three classifications that we set up, they're going to be very important in establishing the duty of the property owner to you. And so if you come for a commercial reason, so they're receiving a benefit for you being there, they have a higher responsibility than the other two categories because they're making money off you being there. So they've got to keep the premises reasonably safe. They also, if they create a hazard, then they may have some responsibility. Now, in the other two categories, it's not the same thing. If you go for your benefit, then it's a higher standard. It has to be willful or wanton conduct, which is much higher than keeping it reasonably safe. And then a trespasser, pretty much, you only have a responsibility there if you know somebody's trespassing, right, then you need to warn them of the hazard, or if it's children, you need to take special precautions in that area.
What does a property owner owe me? What sort of duties does a property owner owe me?
Well, and I think it comes down to, you know, why you're there. So if you go to somebody's house and you're going for a party, what they've got to do is warn you of hidden dangers. If they know of something, for example, just, you know, this wouldn't happen, but say there's an elephant in the ceiling, okay? And they know there's an elephant in the ceiling, and there's an X on the floor, and if you stand where the X is, the elephant's going to fall on you,
right,
okay? And they know that. If they don't tell you, then they may be responsible. So something, you know, and that's just an example. So if they know of a hidden danger and don't tell you, then you have some responsibility as a homeowner. Another issue is if you serve alcohol at your house. You need to be very careful in that situation.
Yeah.
True.
All right, a question that we've got: under what circumstances is a property owner responsible for injuries occurring to individuals while they are on his or her premises?
Yes.
Under what circumstances?
Potentially so. Yeah, that's exactly right. And I know we've kind of jumped in the show and kind of run with it and talked about a bunch of different categories. But, Greg's given some really good examples of things that could happen. But, just some other ideas of what kind of cases, that come from this type of law. Folks who may be going over to a friend's house in an apartment. Right. There may be like a loose handrail or a loose step. I mean, maybe the apartment owner would be responsible. Everything from exposure to lead, lead paint, asbestos, chemical exposures, things that you wouldn't really necessarily think of. A lot of people think of slip and fall, you fall down, you get hurt. But there's so many other areas that someone can be held responsible because of a problem or a danger on their premises.
Well, let's go through a couple of scenarios then, because just ripped right from the headline, so not singling anyone out. But you often hear of shoppers and some sort of commercial outlet, grocery store like you guys talked about, or big box retailer, slips and falls. Should I expect, whenever I'm going grocery shopping, to not be looking out, be wary of stuff on the floor so I can slip and fall? Is it right, is it appropriate for me to expect that the grocery store is a safe place for me just to go up and down the aisles?
Yeah, absolutely, you should expect.
Yeah, you should. Their duty is reasonably safe. Keep it. Right. What that means is, if somebody spills something, depending on the facts of the situation, but say somebody spills something in 30 seconds, it may be arguable that it's not reasonable to have that wiped up in 30 seconds. Right. Now, 5 minutes. It depends. There's a time factor there. So, what is reasonably safe? That's going to be determined by a jury. Right. But just know that. If something's been there for 5 hours, then it should be cleaned up. So like Tyler's saying, you should have an expectation that they're going to keep it reasonably safe, but there's some wiggle room for the premises owner. And so you need to be on the watch out. You need to, don't go in there blindfolded, definitely watch.
Right. Just because you fall on someone's property doesn't mean someone else is responsible. It comes down to notice and knowledge. And if folks have no idea that there's a grape on the floor, it's hidden under, you can't really hold them responsible, but it comes down to notice. If they knew about it, somebody's complained about it before, and they failed to take precautions, well then, the liability starts to shift to the property owner, But if it's one of these things where it's just an open and obvious defect, you're walking and you see a huge hole in the sidewalk, and you're just going to walk right through it. Yeah. Come on. Right. Therefore the liability shifts back towards the person who actually fell. Yeah. And so each case is going to be looked at, on a facts basis. Every case is going to be different. You may have the same injuries related to the same problems, but the notice may be an issue or something like that. So you got to get into it.
All right, time for our first break of the evening. As we head to break, a reminder of how you can get in touch with the firm of Hollis, Wright & Couch. Also find them on Facebook if you search that term, Hollis, Wright & Couch, and on Twitter, Hollis_Wright. Stay tuned. More of The Attorneys coming right up.
I'm Josh Wright with the law firm of Hollis, Wright & Couch, and thank you for watching The Attorneys on Alabama's 13. Now, we hope you, a friend, or a loved one never need legal counsel for a case. But if you do, the goal of this show is simple. Provide answers and legal counsel when you need it the most. Now, your call to the show is free, so if you have questions specific to this show or related to other civil legal matters, call, email, or text us to talk with one of our lawyers. You can also follow us on Facebook or Twitter to learn about important legal news that could affect you or your family. Or simply contact us by going to alabamas13.com and click on the Attorneys link. Now, we know your time is valuable, so thank you for spending it with us and for watching The Attorneys here on Alabama's 13.
Welcome back in to The Attorneys. Appreciate your feedback, getting some good questions from you guys. Love passing them along to our panel of experts. Greg, you kind of piqued your curiosity at that firm fact. You want to add to it?
I do, Dave, and I appreciate you saying that. It's, what we had kind of finished off talking about a few minutes ago about the, that firm fact talked about negligence. I mean, again, this is not what's called a strict liability standard. If you go to another property owner's premises and something happens to you, there's not strict liability. Automatically, do you have a case? And so, like Tyler had mentioned, it's going to depend on the facts.
All right. Let's another question here. All right, let's create a scenario. I've been injured on someone else's property. Let's talk about next steps there. What should I do?
Yeah.
Well, the first thing is seek medical attention. Don't delay on that. Get an incident report created if it's something that if you have fallen into commercial premises, say it's at the shopping center that you mentioned earlier, David, then you want to get an incident report created. Try to, if you're there with somebody else, say you're seriously injured, you need to leave the scene. Hopefully they can stay behind and get some witnesses, get their names and numbers. And also maybe take some pictures of the hazard, whatever it may have been that caused you to fall, and then secure any videotape. A lot of times you're on commercial premises, a lot of times there's videotape of the fall.
Okay. You agree? All that sounds
Yeah,
good?
no, I agree, and a lot of that has to do, if you can identify the property owner. A lot of times you may not. If you're walking, town and you're cutting across an alley, you're not real sure if you're on private property, if you're on city property.
Right.
If you're trespassing at that point in time. Again, it's all going to be fact-based, but do your best to try to get an idea of the scene. If there's some kind of danger there in the street, try to document it some way. Photograph it, do something to kind of so you can get an idea of what the actual landscape, lay of the land was at that point in time.
Yeah. A popular commercial that's out now, an insurance company commercial, the guy's cutting down a tree and it falls on his neighbor's car.
Yeah.
Have you seen that one? In that scenario, I mean, I've even had that happen. I had that happen to where whenever a storm rolled through, a tree in the neighbor's yard fell on my fence and all into my yard. What about those scenarios like that?
Yeah, absolutely. I mean, go ahead.
Yeah, and David, I think you bring up an important point as far as insurance coverage. I mean, that's what that commercial is trying to tell you, and that's something that I think all the viewers need to keep in mind, especially when it comes back to your property and things that you may do on your property for your benefit, or if you're having other people come on your property for their benefit. You want to have appropriate insurance coverage. And so you want to make sure that your policy covers things. For example, that case, the guy's cutting a limb, he damages another guy's car. Hopefully your coverage is going to cover that.
Right.
And you want to have not only homeowners coverage, which is going to help cover the property at your home, but also consider an umbrella policy to also cover other things. For example, if you do have a party, you serve alcohol and something goes wrong.
Right.
That's true. I mean, I think kind of going away from that commercial a little bit, but staying with the same idea is that sometimes things that happen on other people's property can injure you even though you're not on their property.
Yeah.
I think a great example, a case I worked on, it's probably been 10 years, involving a couple young kids coming back from a high school basketball game. And what had happened, there was some construction taking place. Up on the hill, they're building a little subdivision. And during that time, the dirt over time had continued to roll down the hill. And unfortunately, it was right kind of at the point of a kind of a hairpin turn. So over time, because they didn't take any precautions to prevent that runoff coming onto the road, these young men, a little rain had come down, they ran on this turn, lost control of the car. One of the kids was killed, another kid was seriously injured, still very injured to this day. And it was simply because a landowner didn't take the proper precautions to protect folks on the outside.
Right.
And so again, you can have a premise liability type case, even though you're not hurt, on their property per se, but something on their property did affect you.
Yeah. Another question we've got here, and we're talking about insurance. Should I give a statement to the owner's insurance company or accept the settlement offer from the insurance company prior to speaking with an attorney?
My recommendation would be no, okay? And the thing is that and why I'm saying that, and I know I'm an attorney and I'm suggesting that you speak with an attorney, but the reason is a lot of times, insurance companies are in it for money, okay? I mean, they want to cut you loose and pay you the least amount that they can. And so that's why you should consult with an attorney to make sure that you're getting the full amount of the damages that are owed to you.
And I would think if it's someone else's insurance company, it's not your insurance company, so they're not really looking out for you.
Right.
You got to have somebody that kind of look out for what's your best.
That's correct.
interest.
And I know at our firm and a lot of firms in town, I mean, any consultation like that is free. It's just a phone call.
Right.
It doesn't cost you anything. It's not going to lock you into anything. It's just getting some advice, and sometimes advice is your best weapon. You know.
How does a premises liability attorney decide when to pursue a case, when not to? How are those decisions made?
Well, it's like what Tyler said. I mean, it's going to be dependent on the facts, and so that's why, you know, these things that you do after the incident occurs, you know, seeking medical attention, getting witnesses' names, taking photographs, those kind of things. If you do know the premises owner, you know, giving them notice that something has occurred, those things are important, because when you come see an attorney, and hopefully, if you're coming to see an attorney, you're doing it very quickly. The quicker, the better, because like I mentioned earlier, surveillance, videotapes. I mean.
Yeah.
If you wait 6 months, a year, those may disappear. And so you want to, if you have a serious injury and you're considering seeking or talking with an attorney, do so as quick as possible so that they can gather the facts and determine what's going on in the case and see if there is a potential case for you.
That's right. And I think we approach these cases like we do all our cases. I mean, first thing, you have to determine that there's some liability. Like I said, a property owner is not at fault just simply because someone's hurt on their property.
Right.
I mean, so you got to look, make sure there's some liability. Then also the problem that created this injury, you know, there was some knowledge by the property owner. So you have to prove your causation, and then you also have to prove that you're damaged. I mean, just because you fell and you're upset about it doesn't mean that you should bring a claim against somebody.
Yeah.
You know, so we kind of look at it like all the cases. You got to have liability, causation, you got to have damages.
Case by case basis.
All the time.
All right. Time for our second break of the evening. When we come back, the final segment of the attorneys. Again, as we head to break, how you can call, text, email the firm of Hollis, Wright, and Couch. Get those questions to us, or find them on Facebook as well as Twitter. Stay tuned. More of the attorneys coming right up.
I'm Josh Wright with the law firm of Hollis, Wright, and Couch. Serving on a jury can be confusing because there's some information that the attorneys in the case aren't allowed to tell you. And in wrongful death cases, it might surprise you what that information is. In tonight's Legal 4-in-1, we're answering the question, what evidence is allowed in a wrongful death case? Now that's a case where one person's conduct caused the death of another. A wrongful death case is a civil cause of action for someone's death where money damages may be awarded, not jail time. In these cases, a lawyer can only talk about punishing and deterring the defendant for causing the death. That leaves out a lot of information about the person who died, including how that person's death has affected his family and his community. The reason lawyers only talk about punishing and deterring the defendant in these cases is this. In a death case, at the end of the trial, the judge will read a jury charge which says, the damages in this case are punitive and not compensatory. Punitive damages are awarded to preserve human life, to punish the defendant for its wrongful conduct, and to deter or discourage the defendant and others from doing the same or similar wrongs in the future. This means that in Alabama, lawyers can't talk about how great the loss was to a person's family or friends. They can't talk about lost wages or the financial impact on that person's family. Lawyers can't even mention how much that person loved his wife, kids, or grandkids, or what it would have meant to walk a daughter down the aisle for a wedding. In short, lawyers can't talk about all the things that a person who died at the hands of another missed out on in his own life. In Alabama, the legislature has spoken and said that you can't put a value on someone's life. So as lawyers, what we can do, the only thing we can do, is ask that the defendant is deterred and punished for the wrongful conduct that caused the death. We can ask that the jury send a message, a loud message, to prevent such type of death in the future. For example, if a truck driver caused a crash where someone died, the jury can send a message by making the truck driver pay money damages for wrongful death. The hope is that other drivers will be discouraged or deterred from that type of dangerous conduct that caused the death in the case. As attorneys, we often wish we could submit more evidence to the court about the person who died, but we can't. If you ever are a juror on these cases, please keep in mind what we've told you today. Remember, your call, email, or text to the attorneys is free. All of us at Hollis, Wright, and Couch want to help answer your questions on real issues you face. A competent lawyer will respond to every question you send in. That's our pledge and promise to you. Thanks for watching The Attorneys right here on Alabama's 13.
Advice right there. Welcome back into our final segment of The Attorneys. There's still time for you to get your questions into us. Call, text, email, get those into us. A scenario question just came into us. All right. Say you buy a house, an older home, and you buy it from someone, but there you realize there's faulty something, lead paint or there's faulty stairs, and there is an injury. What sort of recourse does that homeowner have in that instance?
Yeah, again, I'd say let's kind of delve into the facts a little bit more. Say this injury probably have to occur within the first so many weeks of owning the house. I don't think you can say, hey, I'm going to go up and down the stairs, for the next year and a half, and then something happened and find out, hey, they were later built out of spec or not to code. So assuming that it happens in the near future, as soon as you purchase the house. If you can establish that the prior homeowner had knowledge of these defects, kind of the same thing. They had knowledge of these defects, failed to disclose those to you, known defects that caused a substantial injury, then absolutely, I think you could certainly bring a claim.
Lead paint, is that still an issue?
No, man.
David, it can be. And going back to this, and then I'll get to the lead paint, on the home situation, two important things. One, ask plenty of questions, okay? Because that's where you can trip up somebody that if they're selling a home to you, you need to ask a question, because if they don't disclose something you ask about, then you may have a potential claim.
Right.
Number two, get an inspection and get somebody that you trust to do the inspection. You may want to go talk to different people. It's very important to have a thorough home inspection. If you have a thorough home inspection, you should catch the stairs if there's a problem, and you may also catch the lead paint, but again, you're going to have somebody that knows what they're doing when they're testing for lead paint.
Right. All right. Question here. Can a property owner be liable for criminal acts which occur on the property owner's premises?
That's a tough question and a tough issue, and we've looked at several cases, and we're currently handling several cases involving criminal acts. I'll say it's criminal acts of third parties, not necessarily criminal acts of the property owner. But say you have a nightclub or a bar, and you're well aware that, hey, in the last 6 weeks, there's been fights break out every Friday and Saturday night. There's been some shootings. There's been folks stabbed. And you don't really, you don't beef up security. You don't do anything about it. You just sit back and just let it continue to happen. I think eventually those criminal acts are going to point to the property owner and say, hey, you had knowledge this stuff was happening. You really should have done something. You should have got some extra security in here. You should have been out in the parking lot. You should have closed down earlier at night, quit serving alcohol, something like that. So it is a heightened standard when you're dealing with criminal acts. And if it's just something that happens out of the blue, unexpected, no prior notice it was going to happen, I would say a landowner is usually not responsible for those things.
And Tyler's exactly right. I mean, really what it comes down to, David, is could you see this happening? Okay, and so if it's just a random criminal act, well, then maybe you couldn't see it happening, the property owner. But if it's happened 5 times in 2 weeks, well, by golly, hey, we almost to a certainty knew it was going to happen. So that changes the analysis on criminal acts of third parties, that type of case, but it is a higher standard and it is a more difficult case.
Okay. We've talked a little about this, but not this specific. A question here about visiting a hotel. Someone recently visited a hotel, slipped and fell. Do they have any recourse against the hotel?
Yeah, potentially. I mean, assuming the hotel had knowledge of this defect or that this product was on the floor or something like that. But when you're going to confer a benefit to a business, you are given the highest protections under the law, and so the hotel has to provide you with the most protection available to any other person that comes in. I mean, you're a business invitee, you're there to confer a benefit onto that business, and so therefore you're afforded the most protection. So in this scenario, there's a good chance that the hotel would be responsible for that.
Absolutely. Like Tyler's saying, David, I mean, it's going to depend on the facts, but you do fall into the number one category. They're making money off you being there, so they have to keep the premises reasonably safe. They can't create hazards.
All right. From the negligence of a hotel to the negligence of a city or a municipality. Walking down a city sidewalk, fell and got injured due to an issue, that the city is responsible for. What sort of recourse there against a government municipality?
Similar, and one of the things is that you need to keep this in mind. Anytime something happens to you with a city or county government, don't sleep on it. Get active with it, because you have to put that city or county government on notice. Typically with cities, it's 6 months that you have to file a notice of claim, and for counties, it's 12 months. So if you have had something where you have been injured on city property or due to some type of city issue, you may want to consult an attorney pretty quickly so you can get a notice of claim filed.
Yeah, that's a good point. We really haven't discussed that yet, and maybe we would have gotten to it, but this is a good lead in. Statutes and limitations, very important on every type of case. And in Alabama, generally for most cases, it's 2 years from the date of injury, or the date of the accident. And that's very true with premises liability cases. If you're hurt on my property or your property or some other business property, it's 2 years from the date of incident that you have to bring a lawsuit. But if the city is involved, that gets shrunk down considerably. Like Greg said, a lot of times it's 6 months with the city.
Right.
And it doesn't mean you have to file your lawsuit within 6 months, but you do have to put them on notice of the claim within 6 months. There's lots of immunities that have been set up over the years for any type of government municipalities, employees of municipalities, and so they're there for good reasons. I understand why they're there, and it makes a lot of sense. But at the same time, when you're dealing with those type of entities, a lot of different defenses and immunities will come into play that just would never come into play with a private landowner.
Right. All right.
And real quick, what Tyler's saying about the statutes, I mean, just because you have 2 years to file the suit, that doesn't mean wait to the very last day and then, hey, I'm going to call an attorney. Because what we have to do is representing individuals that are injured, we have the burden of proof. So when we go to trial, we've got to prove that something occurred, and it has to be more likely than not, which is basically 50.1% we have to show that this occurred.
Right.
To do that, you need evidence, okay? And if you wait too long, that evidence may become stale or not available.
Yeah, true. Just less than 2 minutes left, so time for a final thought. Greg, first from you.
Well, just, I guess, kind of following up on what I just said, if something happens to you, be sure to document it as much as you can through photographs, through witnesses, through medical records. Seek medical treatment and attention. If you know the property owner, go ahead and notify them that something has occurred. And if you want to consult an attorney, do so as quickly as possible.
Tyler?
Yeah, absolutely. I think, like I said, it won't cost you a thing. It'll only take a few minutes of your time. You'll get some of the best advice you can get. Sometimes, consulting attorney can make the difference in, being able to bring a lawsuit and then or not. And so folks may sit on it and realize, and hey, after 2 or 3 years, they realize I should have done this. Don't be one of those people. Go ahead, get it out early, call somebody, and get some advice.
Yeah. All right. Greg, Tyler, good to see you guys.
Thank you.
You too.
Thanks so much. Thank you guys for being with us, and thank you as well. We appreciate your time tonight. As we wrap things up, reminders of how you can still get in touch with the firm of Hollis, Wright & Couch. You can call, text, email. Also, if you'll search the term Hollis, Wright & Couch, you'll find them on Facebook, and Hollis_Wright to find them on Twitter. Please let me encourage you to get in touch with them with any questions you might have. We appreciate you being with us. We'll see you next week right here on The Attorneys.
Thanks for watching The Attorneys, sponsored by the law firm of Hollis, Wright & Couch.